A very good afternoon to everyone joining us today from around the UK and from across the world. Welcome to another Summer of Law webinar from Kent Law School. Delighted to have you all today. Today we will be exploring what public law is. That's the main topic for our webinar today. My name is Mo Afshary. I'm a lecturer in Kent Law School. I teach in both public law as well as criminal law. I've met many of you, I think, in our first Summer of Law a month or so ago, when we talked about criminal law and the legislation in relation to coronavirus. Today, however, we are doing something very different, and I'm delighted to be joined by my colleague, Sebastian Payne. As we hope you will discover, public law is an exciting topic, and we want you to see how we approach this topic, the sort of subjects you will be looking at if you come to Kent, and more importantly, why is it relevant to you as an individual and important for practicing lawyers as well. What we would like to do is, I would like you to have you involved in the discussion as well. Sometimes we will ask you questions throughout the webinar to get your views. You can raise your hands when I ask you to raise your hand or not. And sometimes I'll ask you to make comments throughout the webinar as well. You can use the raise hand facilities as well as the comment section in the chat section of Zoom. I need to also mention that only Sebastian and myself can see your comments, so please do not be shy. Do make sure to make your comments. If you have any questions as we go along, or if you want to have something clarified, do feel free to pop a comment in the chat section, and we will try and answer your question if we have time. I must say that I'm not in Canterbury at the moment. I'm on a boat in Oxford. I'm delighted to be joined by my colleague Sebastian Payne. Let me introduce Sebastian. Well, I have to say Sebastian has a vast knowledge of public law. He is a barrister. He is the president of the UK Constitutional Law Association, a trustee of the Constitution Society, an associate fellow of the Royal United Service Institute in Whitehall, London, and last but certainly not least, a senior lecturer at Kent Law School. Sebastian is an expert on executive powers and the royal prerogative, and has given evidence to many select committees in Parliament. So let me welcome Sebastian. Can I ask you perhaps to, just to warm up, to give us an overview of what public law is before we start discussing different areas in more depth?
Oh, thank you very much, and thank you for that introduction. So just by way of an opening, I think it's important to think of public law in its broadest context, and that context is that it intersects with power and politics. So it's a very dynamic subject, it's very exciting, and indeed it's highly relevant to all our lives. So it's the law relating to government, it's the law that touches on how law is made in Parliament and other lawmaking bodies. It is, in essence, the structuring of public power and the way in which public bodies make law, such as Parliament, and decisions are made by government and the wider reaches of government. Now, it is true that sometimes this term public law is described in a different way. It's referred to as constitutional and administrative law. And I think the simplest way of thinking about it is that public law is the umbrella term for two different topics interrelated. They all form one, but we tend to look at them in distinct chunks, shall I put it like that. So constitutional law looks at the way in which parliaments, the principles of government operate, and the way in which the law-making process is effective. So very much the different mechanisms by which government is organized, and the principles and the law relating to the way government works. And by government, I mean both parliament, the government of the day, and of course the court, so in the widest reach. So that's the broad introduction to constitutional law. And then administrative law is very much about the process by which decisions are challenged in court. So there's more to it than that, but that's the second bit. Now, of course, they're interrelated, because if you're interested in how government operates and what are the principles and limitations, if that's to mean anything in substance, then there has to be mechanisms to make challenges. And those challenges, that system of what lawyers do when they go to court to challenge decisions of government, that's in its broadest sense the idea of administrative law. So public law, the intersection of power and politics, the structuring of it, and the elements of it in its broadest sense, constitutional law and administrative law. So sometimes you'll see a textbook which says public law, sometimes you'll see a textbook which says constitutional and administrative. They are the same area of law.
Very good. Thank you very much, Sebastian. So before we dig deeper into some of the specific areas in public law, particularly constitutional and administrative law, let me sort of set out some of the outlines of what we're going to do for the rest of this webinar. So what we want to talk about is basically when in public law, essentially, we're talking about the powers of some very prominent people within the UK Constitution, the Prime Minister, the Queen, members of Parliament, ministers of the state, and so on. So what we're going to do today is to use examples of the two recent cases called Miller 1 and Miller 2, otherwise known as Brexit cases, to illuminate how law gives power and also limits the power of those people with power. So first of all, however, we need to cover some basics. We're going to have a discussion about the basic concepts of the UK Constitution. Essentially, we're going to say a few words about what the actual term constitution means and consider, say, themes that are central to the UK Constitution in particular, including the separation of powers, conventions, parliamentary sovereignty, so on and so forth. We also want to talk about sort of these two cases, which are, as I said, quite well-known cases, constitutional cases, and discuss in a way how they relate to sovereignty of parliament, separation of power, and those different principles of the UK Constitution. So if you come to Kent to study public law, what normally will happen is in your first term, much of what you will be studying is based on constitutional law, and much of what you will be doing in the second term will be based more or less on the administrative law side of public law. And I'm going to sort of keep that structure in our webinar. So we will start with constitutional law, some of the broader principles. I would like to now turn to Sebastian. So you give us a broad outline of what public law is. Perhaps we can move on to discuss some of the distinctive characteristics of the UK Constitution. So why don't you tell us maybe a little bit about what a constitution is?
Yes, but before I do that, I'd just mention that when we're looking at government, we're looking at government in the broadest sense at different levels. We're looking at devolved government, and the public law sphere also, just to set the scene, involves all the agencies of government as well. So it's not just the Prime Minister, for instance, or Parliament. It's quite a wide reach. But Mo's asked me to then think about the idea of constitution. So we'll think about both what the Constitution is in the broadest sense, and then we'll move on later to look at some of the specific features of the UK Constitution. So you'll see that first slide, and it asks the question, what is a constitution? And what you see in front of you in terms of the slide is actually an attempt to identify some of the core elements that one would expect in any constitution. So, for instance, if we're looking at public power, we're looking at what is called, some of you may well know, the three branches of government. So that the idea that there are different aspects of government. One part of it is called the government, or the executive. So that's one branch, the people, the ministers, the prime minister, and so on, the government of the day. So that's, you would expect a constitution to structure and distribute power between the different branches of government. So if you've got the executive, which is the government today, you've also got the lawmakers, the people who debate and discuss and propose law to be made by Parliament. So they're the lawmakers, and we talk about Parliament in the UK context as lawmakers. In other countries, of course, for instance, in the US, the United States, it's Congress. But typically in the Westminster style system, we talk about Parliament. And then you have the judiciary, which is the court and the judges. So a constitution needs to determine how those powers are going to be distributed, under what circumstances they can be used, what is the remit of the government of the day, the prime minister, the first minister, the circumstances in which the formalities for the lawmaking process, and also the role of the courts. So that's what you'd expect in any constitution. Now, we come to some specific details, which is most countries in the world have what is called a codified constitution. It will be the founding document, the key document that sets out what is in the constitution. And that's very important because that document will have a very important status. It will be regarded as, in effect, the highest status law, as it were, that determines the conditions under which government, Parliament, and the judiciary can act. So that's called a codified constitution. But just to make things more interesting or perhaps more complex, the United Kingdom has an unwritten constitution. And that's the term that's often used. People say, it's not unwritten, there are documents. Well, that's true, there are documents. So it's simplest to think of the UK's unwritten constitution as meaning it is an uncodified constitution. So in the United States, for instance, as an example, there is the United States Constitution, or the French Constitution, the Italian Constitution, or the Constitution of Uganda or Egypt. They will be written down and they will have a special status. But the United Kingdom does not have such a set of arrangements as one document. So it does have structuring of government, but it's an unwritten constitution. So it's no single written document that you go to saying, this is the power. So if that's the case, then how does the United Kingdom identify their constitutional features? And as you can see from the end part of the slide, the last section of the slide, the UK Constitution has a number of different sources. And there are Acts of Parliament, in other words, the law made by Parliament. There is case law, and by case, you may have considered this in an earlier webinar. Case law involves the decisions of judges. So the judges in the UK system create a body of rules and norms and laws. And there are also accepted customs as well. So those customs are called conventions. Additionally, and I suppose this wouldn't be unique to the UK, but it has a unique significance, the writing of academic constitutional experts are also referred to as well. So you have a sort of mix of sources: Acts of Parliament, the rulings of judges, accepted customs, which are crystallized perhaps or manifest in what we call conventions, and I'll speak about those later, and leading academic constitutional texts. So that's a sort of mix. Now, of course, that creates an interesting set of problems in itself when you've got such a diverse range, but maybe we'll discuss that a little later.
Yeah, that's very interesting because I suppose one of the questions that this raises, Sebastian, is that now we have a system where the constitution, as you said, is not written in one single document. And there is a whole range of different sources that are collectively referred to, as you just said, as the UK constitution. But I suppose the question that it raises is, well, is this an effective constitution when it's by nature not written in one single document? So I suppose, and historically there have been debates about perhaps the advantages or disadvantages of having a written or an unwritten constitution. So perhaps what we could do is, I would like to perhaps start with asking a question from our audience. I'm just curious as to what we think. So let me ask the audience a question. Do you think it makes any difference if a constitution is codified or uncodified, as in the case of the UK? So if you think an uncodified constitution is more effective, please raise your hand. But either way, if you think it is or is not effective, we would like to see your comments about why you think a codified or an uncodified constitution, it may not be as effective as the other. So let's see how many people have raised their hands in terms of whether an uncodified constitution is as effective.
So let's just recap. An uncodified constitution is where there's no single document, as in the United Kingdom. There are only 2 or 3 countries in the world where that applies, as it happens.
Okay, so some very interesting comments also been made by our audience. For instance, uncodified constitution is easier to change, perhaps. Uncodified constitution can change with times. It's a very interesting point. Another audience, somebody else has just said that uncodified constitution is better because of separation of powers and checks and balances. Also, another common interesting one, that even codified constitutions seem to be altered by amendments. So the advantage of having it set in stone seems less clear, perhaps. So it seems a lot of people are sort of referring to the difficulties of changing a written constitution, whereas in relation as against the flexibility of having an uncodified constitution. And I suppose, as I can see, majority of our audience agree with the fact that perhaps an uncodified constitution seems to be more desirable. So perhaps let me turn to Sebastian now. Sebastian, what do you think? What's your views on the differences between an uncodified and codified constitution, particularly in relation to the difficulties or perhaps the advantages in terms of changing constitution over time?
Well, that's often, I'll respond to some of the points that you've mentioned have been made as well, but to answer your question immediately. So the argument is is an uncodified constitution easier to change? Is that an advantage? Or is there a problem with a written constitution because they're harder to change? And people often refer to the right to bear arms in the United States as an example, which is in the Constitution. A lot of people think it's a great idea that citizenry can wander around with guns, and other people think it's asking for trouble, shall we say. It's very difficult to change the United States Constitution. In principle, it should be easy to change the UK Constitution because there's no single document or no process of amendment. But that's actually not what happens. The UK, it is true that there can be a change to the constitution, for instance, by an act of parliament. If you look culturally at the political arrangements, actually the UK is quite resistant to constitutional affairs. For instance, the upper house of the UK Parliament is the House of Lords. And that was a house made up of hereditary aristocrats or peers. They were talking about repealing that or changing that in the 19th century. And still to this day, the UK has an upper house with peers, of which just under 100 are still hereditary aristocratic peers. So I think what's very interesting about public law is you've got on the one hand principles or ideas, and then the practical reality of what happens. So for instance, on this question of should we have an unwritten constitution because it's easier to change? Well, actually, although the United States Constitution is difficult to change, many other constitutions actually create the possibility of change in a much simpler way. And if you look at some of the literature, I think the period in which constitutions are changed is in years rather than in hundreds of years. So I think that the balance, I haven't said which I would prefer. I mean, I'm happy to share that, but I think maybe we'll leave that discussion. But just I'm trying to identify what people are saying, the comments they're making, and talking about which is better. So for instance, somebody said, well, a codified constitution is clearer. Of course, the powers would be set down much more clearly, although they are subject to interpretation as well. So it's not that a written constitution, everything is completely decided, but the main parameters would certainly be set out in a way that as you look closer at the UK constitution, you'll see that there are diverse elements. And as one person asked, who gets to decide what the constitution is? That's a very good point. So if you have a written constitution, the people who, I think that's called the constituent power, who gets to constitute the overarching power of the state. So with a written constitution, the people who decide could vary. So for instance, in the US, it's the founding fathers, or it could be a number of people. It could be a military takeover, for instance, and it's imposed, as happens in some countries. It could be by referendum. There are many diverse ways in which a constitution could be decided. An unwritten constitution, that's the second part of that point that was made. In an unwritten constitution, as in the United Kingdom, the question is, who decides what it should be? That's perhaps a little different from who made it what it is, but in the UK constitution, the ultimate decision maker as to the constitution is either Parliament because it passes acts of Parliament, or the courts if it's a question of interpretation before the courts. So it's either Parliament or the courts, or perhaps both.
Okay, and I suppose perhaps obviously the uncodified nature of the UK Constitution is a major distinction, major difference between the UK and many other constitutions around the world. But that's not the only distinctive feature of the UK Constitution. There are a number of other features that the UK Constitution particularly has that many other countries don't. Perhaps maybe I can ask Sebastian to tell us more about some of these other distinctive features of the UK Constitution, if you can.
Certainly. So we now move on to that second part. Of course, I should say the subject is vast. So this is obviously an introduction, and it's the constitutional aspects of the UK system. So we've talked a little bit about the overall sort of format of the UK Constitution being unwritten. Just touching on a few, this is not meant to be exhaustive, just to highlight a few features of the arrangements. And then you can see that this is the intersection of politics as well. So for instance, in the United Kingdom, we have what's called a Westminster system of government. And what that means, which many of you may know, but for those who don't, the Westminster system of government means that the two branches of government, the government of the day, the executive, and the lawmakers, Parliament, they are in effect fused in the sense that the government sits within Parliament. So that's quite distinctive. That's actually a very important structural feature of the Constitution. So, for instance, if you watch Question Time, it's the Prime Minister going to the House of Commons, in the lower house, and answering questions. So the government and the ministers and the opposition, the official opposition, are in Parliament. So that's the Westminster system of government. It has a lot of implications. Of course, somebody already mentioned the idea of separation of powers, and we'll also explore that a bit further. But what it means is that there is some form of accountability directly in terms of answering for government policy, proposing government policy. It's quite a robust system in that sense. But of course, in another sense, it doesn't keep the branches separate. It sort of overlaps. So the House of Commons is made up of all the MPs elected, and the government of the day are made up of the ruling party, ruling in the sense of forming the majority and therefore entitled to rule. So that's one feature. We then turn to another feature, devolution, and that's in its, there have been elements of devolution in the United Kingdom before 1998, because the Northern Ireland Parliament was dissolved, and earlier on in the 18th century or the 19th century, there was Irish Parliament, or earlier on, All Ireland Parliament. But what we look at now in terms of devolution are the arrangements that were brought in by Tony Blair's Labour government that came into power in 1997. So they devolved, in other words, created a separate layer of government for Scotland, Wales, and Northern Ireland. Now, I know this may be old hat to people, but I've been talking about the United Kingdom. And the United Kingdom is the United Kingdom of Great Britain, which is England, Scotland, Great Britain and Wales, and Northern Ireland. So there are sort of said to be 4 nations, and 3 of those nations have devolved government, so the lower level. So Scotland has a government, Scottish government, and a Scottish Parliament. The Northern Ireland has a Northern Ireland Executive and Assembly, and the Welsh government there's a Welsh government, and what was called the Welsh Assembly is now referred to as the Welsh government, or Senate. So that is one level. So you've got one, the UK system is said to be a unitary state, which means that the centre, the United Kingdom nationwide government, is meant to be the sort of leading authority, but there is also devolved government too. It's not a federal system which would divide powers between the sort of central government and local government. So that's one aspect of enormous importance. And I think one of the distinctive features, which really links to the Westminster system of government, is the power of the executive with regard to Parliament. So because the UK does not have a strict separation between the lawmakers and the government of the day, and the government of the day is made up of the majority party, one of the implications of that is the executive government is very powerful in terms of lawmaking, and in essence it sets the agenda, and because it's in power, because it has majority, it can essentially in most cases push through its program. Whereas in other countries you might have an elected president and then a house of parliament or congress. The president may have one party and there might be a different party in congress, and then you get some form of gridlock. But in the UK system, the government actually directs a great deal of what happens in Parliament, and that's amplified by the internal rules of Parliament as well. Something that until recently academic lawyers, public lawyers, haven't spent that much in terms of, certainly in terms of, but the whole inspection of the internal rules of Parliament have turned out in recent years to be of the utmost importance. So that is another key feature. And then we come to something called the royal prerogative. And we'll be talking about that a little more when we look at the Miller cases, Miller number 1 and Miller number 2. But that's a distinctive feature of the UK Constitution, that the government has powers called royal prerogatives, and they are historically the powers of the king. They are a form of executive powers, and they are not granted directly by Parliament, but from a historical source. So you can talk about the United Kingdom's historical common law constitution. Put another way, you could say that because these are powers not granted by a single codified constitution, these powers have evolved historically, and some of the ancient powers of the king have survived, have not been granted directly by Parliament, have legal authority, and are for the large part exercised by the government today. So you've got on the one hand this oddity of the historical source. It's not odd in the sense that you can see how it arrived, but it's odd in the sense that you've got these ancient powers before democracy, which the king had, which have survived. So I think those are very distinctive features of the United Constitution. I should say, it's not just in the United Kingdom that these prerogatives exist, because the historical implications of Britain's empire, I guess, meant that many countries have some similarity of structure and indeed prerogative powers. Just to put it in context, non-Westminster system governments often have executive powers, but they wouldn't necessarily have them in this particular form.
That's very good. Thank you, Sebastian. I'm sure our audience appreciate that these concepts and principles that Sebastian is introducing and describing are very complex, as yourself mentioned earlier. So we're not really trying to provide some kind of an exhaustive description of these concepts. In fact, that is what you will be doing throughout your first term, being introduced to all these principles: separation of powers, parliamentary sovereignty, rule of law, the royal prerogative. Any of these principles can particularly be challenging, and of course the idea is for us to go through each of these principles one by one, study them, talk about them, discuss them, and so on. So essentially, your first term of studying public law involves looking through and looking at these different principles. Essentially what constitution and constitutional law is and how it operates in the United Kingdom. But then there is a second dimension to public law, which is the administrative side of public law, which is as equally interesting, but could also be as equally challenging. So perhaps what we can do, we can move to administrative law and say a few words about what it is and how it's different. Because in my experience also, many students find certain aspects of administrative law particularly more interesting. Whereas sometimes principles such as constitution, separation of powers, and rule of law may seem somehow abstract. But when you come to administrative law, particularly in relation to judicial review, which we will be talking about in a minute, and cases that sort of are examples of judicial, many students find them really interesting, which is why we're going to hopefully, if we have time, to look at two particular cases of judicial review. So perhaps what I can do is ask Sebastian to give us a quick overview of administrative law and sort of explain to us particularly the functions of judicial review, if you please.
Yes, I'll happily do that. So as Mo was saying, the second term under the umbrella of public law, the second large element of what we're looking at is administrative law. And administrative law is in essence the set of legal mechanisms and procedures by which the powers of the state and the lawful exercise of the power are challenged, or rather, there may be questions as to whether their powers have been lawfully exercised. So the administrative part, I guess, is the element which is how do you, or on what basis would you make a challenge to the actions of government? So as I mentioned in the earlier part of the discussion, when we're thinking of the government, or more broadly the state, the sort of things government does, and the remit is both central government, local government, devolved parliaments and executives, and also beyond that, we're looking at other things that are regarded as public law matters, which are the disposition or the application of government services, so the National Health Service, what the police does, and education. They all form aspects of public law. And all of those, so because government is meant to act under the law, it's not meant to just make up its powers, it's always open to potential challenge that it has either not proceeded properly or has failed to act according to its lawful remit. And so that's what administrative law is looking at. So just in the broadest terms, we might be talking about court-based activity, a challenge. There may be also tribunals, which are not necessarily courts, but maybe tribunals to deal with things like employment challenges over employment benefits or housing or educational needs, those sort of things. And the third aspect is that of the Parliamentary Ombudsman, who has a special remit under the Parliamentary Commissioner Act to deal with what is called maladministration, bad administration. So it's not a court-based remedy, but sometimes the question is not whether it's a breach of law, but whether things have been organized so badly that it's actually harmed the individual or caused some form of injustice. So that, in its broadest sense, is administrative law. And what I'm now going to turn to is the specifics of one of the legal processes, in fact, the main legal process. I say main in the sense of the most prominent, not necessarily numerically, I should say, because there are challenges, there are many tribunals where there are challenges over immigration matters, housing, as I mentioned, welfare benefits and so on. That could be a vast number, but the high profile one, shall we say, is judicial review. And that is a procedure that takes place in the High Court in England and Wales, and the equivalent in Scotland and Northern Ireland. So as you can see, it's a court-based remedy against public bodies. So that term public bodies is, in a sense, a term of art. It's what I'm talking about, those organizations, be it government, local government, police, National Health Service. You might be able to challenge what they do. But it's got to be for a purpose, as it were, not just because you don't like it or you don't agree with the policy, because that would be a political matter. It would have to be a legal matter. And there are limited grounds for challenging decisions of government. This is called the supervisory jurisdiction of the High Court. And it's the claim for judicial review, as it's called. And the three grounds under which you would challenge it, the three main grounds are questions of illegality, procedural impropriety, and irrationality. Now, they are in themselves quite complicated fields, but put at its most simple. Illegality is where a decision maker hasn't had the lawful authority to act or failed to act within the way in which that they should have done. So, for instance, they might have excluded a relevant factor, for instance. Procedural impropriety is the area where they have not followed the proper procedure, and that's in itself quite a big field. I'm just highlighting it. And then irrationality is a slightly unusual term, but it's where a decision is regarded as completely unreasonable. So those are the grounds. And there is a fourth ground, I should say, and that is proportionality, which is a special test applied in the area of human rights law, whether an action that infringed rights was disproportionate. And in the second term, we would be looking at detail of those. And of course, what's important is that is what, if you're standing up in court in front of the administrative court arguing a case, you would have to bring your case on behalf of your client under one of those grounds. Either that the decision maker stood outside the law, they followed the wrong procedure, the decision is completely unreasonable, or that it was disproportionate because it went further than was necessary in harming someone's human rights. I say, you might say, well, why can anyone's human rights be harmed? Well, there are circumstances in which human rights can be limited, but the objective's got to be legitimate. So that's under the fourth category. You can see breaches of human rights. Breaches of human rights are also challenged under judicial review.
That was brilliant. Thank you, Sebastian. I hope our audience have some understanding of these grounds, particularly, as I said, many students often find judicial review particularly interesting in the second term. And in that spirit, I think two of the cases, most recent cases that kind of nicely show us how administrative law, particularly judicial review, works in relation to questions of constitutional law, separation of powers and parliamentary sovereignty, are the two Miller cases from 2017 and 2019, which I would like us to move to the first Miller case, in fact. Those of you who were following British politics may remember, in case you haven't heard the news yet, in 2016, we had a referendum, a national referendum, by which we decided to leave the European Union. Now, obviously, it raised a lot of political, legal, social questions, which we don't have time to go to. But one particular and one very interesting question that it raised was a legal question. And the question was, okay, so we have decided to leave the European Union, and the Treaty of the European Union has a particular article, Article 50, in which the article says, if a member state decides to leave the Union, they need to serve a notice to tell the Council of Europe that they would like to leave. That notice, Article 50 notice, usually triggers a 2-year period in which there will be negotiations. Eventually, at the end of that 2-year period, that member state will be leaving the European Union. Now, the question that was raised, an interesting question that was raised, and as I said, it relates to all these constitutional matters as well that we just discussed, is who is going to give that notice to the European Union? Who is in charge? Who will decide whether and how we're going to give that notice? Can the UK government, can the Prime Minister at the time, Theresa May, can she use her prerogative powers to give notice to the European Union of Article 50? Or, given that we are a parliamentary sovereignty constitutional system, should Parliament make a decision? Should Parliament vote on that before the government has the power to invoke Article 50? So this was a question that was raised in Miller case. Gina Miller, well, she is and was a business owner, effectively a member of the public, if you like, and this is what's interesting about judicial review, members of public directly can challenge the government. So she brought in proceedings against the UK government, the Prime Minister at the time, Theresa May, because the Prime Minister was proposing to give Article 50 notice using her prerogative power. Gina Miller's challenge was that, well, she needs to get the approval from Parliament before she can give that notice. So that ended up in courts. So what I would like to now ask Sebastian about is perhaps you could tell us a bit more about what happened in court, particularly, so what did the court say, what was the outcome, and why was it particularly important in the UK constitutional system?
Thanks, Mo. Well, if I may, I think I'll quickly just recap on a couple of points, just to make sense and highlight one other thing. So we've talked about the royal prerogative, these powers that the government has, that it has inherited from the monarch. And I should say that the UK is a constitutional monarchy. In other words, the head of state is the Queen. And so you've got this apparatus, legal conceptual apparatus, the crown. But we're not talking about the object the Queen puts on her head for the state opening of Parliament. We're talking about it as an abstract set of ideas, essentially for the state, for the operation, the legal operation of that. So the government has a whole raft of prerogative powers, and one of them is the prerogative relating to treaties. So the UK joined the European Union by signing a treaty, and then they incorporated the obligations of the treaty through an Act of Parliament, the European Communities Act. So that was a treaty. So the Prime Minister, the convention, the custom is that the Queen doesn't make that decision herself. She acts on advice. So when we joined the European Union, it wasn't actually after a referendum. It was a vote of Parliament to approve it. But an Act of Parliament was used, the 1972 European Communities Act. So as Mo said, we are a system that believes, or the constitution is meant to be strongly based on the idea of parliamentary sovereignty. And we haven't talked about that, but some of you will know what it is. But just in very simple terms, parliamentary sovereignty means that Parliament is the ultimate lawmaker. Their laws are at the top of the tree, shall we say, the most important laws. And it's also the focus of political debate. So it's the key political decision-making forum in most aspects in terms of lawmaking and debate. Now, it's true that the government that sits in Parliament takes key decisions as well, some of which are through the prerogative. So you've got this strand of authority of executive powers that the government has, that's not granted by Parliament. Simultaneously, you've got this idea of parliamentary sovereignty, that the focus of the political decision-making is via Parliament, and also that their laws are the top laws in a hierarchy. So that's the background. I think it's important just to set the scene. So the issue there was, historically, the prerogative, which are law, prerogative powers are lawful, they give the government the power to enter into treaties. It also gives the government the powers to leave a treaty. And that's what, in effect, the government would be doing. So the treaties of the European Union, which Mo mentioned, the Lisbon Treaty, Article 50, there was a device by which we could trigger our departure. We would give notice to leave the European Union, negotiations follow, and we leave either when those negotiations are complete, or if they're not complete before 2 years, we leave anyway. So the issue before the court was, the Prime Minister wanted to use the power that governments had always used to regulate treaties, to trigger our desire to leave, which would be effective within 2 years, unless there was an extension. But Gina Miller and other people objected, because what they said was, in essence, that if you use that prerogative power, you will be ending the legal obligations of the UK. So when we joined the European Union in January the 1st, 1973, we created a whole new legal order by being a member of the European Union. And therefore, by prerogative, if you trigger Article 50 to leave, you will, as the argument went, you will implode that legal, destroy that legal set of arrangements. So that was a challenge. Did the government use this power? Because they've always used that power to regulate treaties, or was this a novel situation which in effect required Parliament to decide? Well, what happened was, in this case, the court said, it was a split decision, they didn't all agree, but 8 of them out of the 11 said that in this circumstance, the government could not use a prerogative because it would destroy a whole legal set of arrangements, and it would effectively change the law of the land, and that it was for Parliament to do that. So in fact, the government were told that they could not use a prerogative, so they had to go back to Parliament. They did achieve what they wanted, but they had to do it through Parliament.
Very good, thank you, Sebastian. And I suppose at the time and since then, one of the questions, major political question that this particular case from the UK Supreme Court raised was, well, should the judges be allowed to intervene in this matter? Is that right for the judges to effectively be the final arbiter between the government and the parliament in relation to the invoking of Article 50? So what I would like to do now is perhaps I could ask our audience about your views. So do you think, this is my question to you, do you think it was right for the courts, for the Supreme Court in particular, to be asked to take this decision? If you think it was right for the court to be asked to take a decision, please raise your hand. And feel free to comment on my question. If you have anything in particular you want to say, feel free to comment as well. Okay, that's interesting because we seem to have sort of some kind of a split. A large number of people think it was right for the courts to be asked a question, but also there are quite a few people who think it was not right for the courts to intervene. So maybe briefly I can ask Sebastian for your view. Do you think it was right for the courts to intervene?
Well, I noticed one of the questions, one of the comments from the participants was that judges should stay out of politics. And I noticed somebody else said, well, we didn't elect the judges. So I think the important issue though, I mean, the comments are fair comments insofar as we don't expect judges to make political decisions. I think the key thing here is that in fact, that what is an issue is what is the scope of the law. So that is a legal question. Now, not everybody, I mean, it is a question of legal fact that a power of the executive is based in law. And so the question is, what's the scope of it? Whether you like the answer you got from the court or not is another matter, but the issue is, how far is the power? Now, it seems to me that that is central to what the courts do. They assess what is, in public law, what is the lawful remit of the government in terms of their lawful authority. Now, of course, we could debate this in much more detail, as indeed we would. For instance, somebody has said it's important for Parliament to recognise the supreme body. So what you've got here are different things. You've got this, in essence, what the court was saying is the government can't do this because it would undermine the supremacy of Parliament. So what the courts really think they were doing is actually upholding the democratic structure, because prerogatives weren't actually granted by Parliament. They were historical powers that were left in the hands of the king, now exercised by government.
Well, that kind of nicely takes us to the second Miller case, because it was also essentially a very controversial case where, again, the Supreme Court got involved and there was a lot of debate about whether they should or should not do that. But the Miller 2 case, so let me briefly just give a recap of what the case was about, and I'm going to ask Sebastian to tell us a bit more about it. So I suppose many of you might remember that in 2019, the Prime Minister of the time, Boris Johnson, decided to prorogue Parliament. That was in September 2019, and he decided to prorogue Parliament for 5 weeks, using his prerogative power again, the same power that his predecessor, Theresa May, wanted to use to give Article 50 notice. So then the question that was raised was that, did the Prime Minister have this power? Could the Prime Minister use prerogative power to prorogue Parliament? And again, General Miller challenged the decision of the Prime Minister in courts, and the case ended up in the Supreme Court, like the Miller 1 case, and So perhaps I can ask Sebastian to tell us a bit more about what was the main issue and sort of effectively what was the final decision of the court.
Yes, and I noticed one of the comments is proroguing to suspend Parliament, and the person who put that comment is exactly right. That's what's happening. When Parliament is prorogued, the session is suspended. So the session is ended. It's like terms of an academic year. So you've got the life of the Parliament, 5 years, and then it breaks up into session, like an academic year perhaps. And it's to end one session before bringing another. So the government, again, historically had the power to do this by prerogative, to suspend Parliament. So that wasn't unusual. It wasn't unlawful for them to prorogue Parliament generally. But what was happening here that's so important is by suspending, we were just on the verge of exiting from the European Union. There was masses of things to be debated, discussed, analysed, more laws to be passed. By suspending Parliament, using the prerogative, the argument was that it was essentially torpedoing the function of Parliament. And so that was really the fault line. So yes, it's true, this is effectively what the court said. Yes, it's true that there is a prerogative to suspend or prorogue Parliament, but under these circumstances, if we let you suspend Parliament, you will be undermining both the political accountability of the government of Parliament and Parliament's lawmaking, both of which are vital to the constitutional arrangements. And they did this in a very intriguing way, which was to say it's a question of scope of power. Anyway, we will certainly, to be continued, I guess. There's plenty to discuss. That's a mere sort of short introduction. And I see the comment, someone has said, I think this shows that law is necessary in politics. Well, yes, I think that what a perfect summary. That's really, if you say, what's the point of public law? It's that law is necessary in politics.
Yeah. Thank you, Sebastian. So this obviously raised a lot of questions. These are questions we will be looking at when we discuss Miller cases in your second term. Should the courts be involved? Should they have power to limit the exercise of power by Prime Minister? What would be the problems when the courts become too active? Or what would be the problem if the Prime Minister see him or herself as beyond the reach of court? These are all really important questions that we will discuss. Unfortunately, we are running out of time, so I would have loved to continue this discussion, but I hope this discussion has given you an idea of the sort of subjects that we will be looking at in public law and why public law matters. So when you can come to Kent, you will be actively involved in researching things, particularly these cases and the issues involved. As a critical law school in particular, we always consider the context, the social and political context in which law operates, and ask how well the system works, whether it's a fair system, or how could the system be improved, if you like. In your lectures, seminars, and discussions that you will be having, your writings and so on, the idea is for you to develop your knowledge and skills to pose those kind of questions, and obviously, and hopefully have informed and analytical points of view at the end of it. So I would like to thank all of you who joined us. I also want to thank Sebastian for your really brilliant summaries of all these different, very complex matters. Perhaps if I can briefly ask you to tell us perhaps 3 main points that we can take away from our discussion today.
Well, I just want to say, I noticed a lot of the comments as we were talking, and they were very well informed. So there's plenty to be discussed in the future with lots of active, bright minds, and I look forward to doing that. But to answer your question, yes, I think what's important about public law is that public law lies at the intersection of politics and state power. That's the first thing to say. It's very important. Second thing of why it matters is that what government does affects all of us. And the last point I would say is that understanding the Constitution and the legal mechanisms to challenge power is very interesting, and it's a vital skill for a lawyer.
Thank you very much. Thank you, Sebastian, so much for your participation. Finally, I'd like to thank everyone, all our audience who joined us today. It was a delightful session. I really enjoyed having this conversation, and thank you for your contributions as well. As you can see on your screen, if you would like to read up more about the Miller cases, or even you can watch the Supreme Court in action, you can go to their website, as you can see on the screen. Also, for topical analysis of public law issues, you can go to the weblog of the UK Constitutional Law Association, as you can see on the screen as well. But thank you all for your participations. I very much we look forward to seeing you in person or online in September. Have a great day and see you soon.